Um, Hello, if you're joining us. I'm Jennifer McDougall. I'm the past president of ACC San Diego, and I'm looking forward to this webinar. And so I thought I would just take this moment to thank Allen Matkins for being a long time awesome sponsor of ACC San Diego and bringing us great information and content like this. And I will now turn it over to Seth, Mike, and Megan to introduce themselves and share what they have.
Good morning or good afternoon, everyone, I guess, 12:03. My name is Seth Garrett. I'm a 7th year associate at Allen Matkins, specializing in transactional commercial real estate. And we're going to be chatting a little bit about trends in commercial real estate, over the past 12 to 18 months, obviously COVID implications, and maybe some other areas of the law that have been a little bit more exposed lately. And myself, Megan, and Mike just want to hit on a few different areas in short, kind of at a high level. And then obviously we'll open it up to questions. But Megan and Mike, if you want to introduce yourselves, and then after that, I'll just jump right in.
Great. Hi, everyone. My name is Megan Thiels. I'm a 3rd year associate at Allen Matkins. Since I'm on this panel, of course, I do leasing work and general real estate, other kind of practice areas. I also have a focus on construction contracts, so I'll talk a little bit more specifically about tenant improvements and work letters today. Mike?
Hi, everyone. Mike Holmes. I am a real estate partner here at the firm. I've been with the firm for over 20 years, and I'm going to be talking about the fun topic of everyone coming back from quarantine with their dogs and those issues that we've been seeing lately with that happening, as well as a disclosure provision from a statute that was enacted a few years ago that you all may be familiar with, but want to walk through some of the details of that statute and what's required for those disclosures.
Awesome, thanks, Megan and Mike. So just a little bit more of a elaboration on an introduction to myself. I was a commercial real estate broker in my past life. So after a 5-year career as a commercial real estate broker at CB in Phoenix, Arizona, I transitioned to become a law student in San Diego, California. So fast forward 11 years later, now as an attorney, I have a broad-based commercial real estate transactional practice where I handle a wide array of commercial real estate transactions and product types. It's good to see some familiar names on the Zoom. I see Chanel's on here. I went to law school with her my first year. And Paul Datnow from Qualcomm is on as well. And my wife works at Qualcomm and knows Paul quite well. So it's good to see some familiar faces, and I hope to see all of you in person soon. I have a particular emphasis on commercial leasing matters from the perspective of both tenants and landlords. And as a recovering commercial real estate broker, I try to take a practical approach to negotiating lease terms. And I know speed to execution is critical. So I try to bring my deal-making knowledge and experience gained on the brokerage side to best position my Allen Matkins clients for advantageous legal transactions. So with that being said, my portion of today's presentation is just some high-level tips on how to best negotiate, or in some instances renegotiate, renew, or protect your lease terms. And so, as we all know, COVID-19, the pandemic, has disrupted all businesses, and some of these concepts will be a little bit, backward-looking, but it's still very much in play today, as we have the Delta variant going around, and maybe some more restrictions coming back on in California. So, when the pandemic started, there was a lot of rent relief given to tenants and extended lease terms, which we'll talk a little bit more in detail about. And then there was also eviction moratoria put in place at county levels and city levels. I just wanted to give a quick update on the eviction moratoria. Some of you might be well aware of it, but currently there's no eviction moratorium currently in place for commercial tenants in the city of San Diego. However, commercial tenants who are entitled to rent deferral under the prior moratorium have until December 31st of this year to pay back rent. and landlords are prohibited from going after commercial tenants based on non-payment of such rent until January 1st, 2022. So, with that being said, the moratorium expired on June 30th, 2021, just a couple months ago. So if a tenant fails to pay rent after that, the landlord may send the tenant notice to pay or quit based on the failure to pay that rent. So after that June 30th, 2021, and then bring an unlawful detainer action if they fail to comply. So just a quick update on where it stands in the eviction moratorium as it relates to commercial tenants. And then again, work from home policies are affecting all of us. We aren't immune to it ourselves. We're a law firm. We're a big user of commercial real estate downtown San Diego. And so what's the work from home policy going to look like for each and every company? It's going to be different. Do we need more or less space? Do we need what we call right size our premises? And then there's also lender implications. As tenants, sometimes we get stuck with dealing with just a landlord, but oftentimes there's a lender on the project as well. And so there might be some covenants in the loan agreements that affect commercial leases of tenants as well. So these are usually three-party transactions that are complicated and take time. So just to touch on some of the legal rights of tenants as we kind of got into the pandemic and are coming out. The first one being the famous buzzword force majeure, which I'll go into a little bit detail at the end of my time, but that's a legal right that a tenant does have to withhold some performance under a lease in the event of an act of God, or however it's defined in your lease language. Access to premises, interruption of essential services, and governmental action. So those three prongs, tenants were trying to argue, and some successfully, that they couldn't get into their space. There was an interruption of services, and there was governmental action that was preventing them from operating. So with that being said, as we're coming out of the pandemic, or I guess, landlords and tenants are learning how to work together during the pandemic. The key takeaways, when you're negotiating with your landlord, either on a new lease going forward or a renegotiation, just communication, being proactive and reasonable with landlords. Megan and Mike might touch on it, but there might be some new legislation coming forward to change what the current legal and contractual obligations are. There's cases being litigated with everything going on in COVID, and we're not really going to know that precedent, for another year, 3 years maybe, after that goes through the courts. So it's all about transparency and fairness, when you're negotiating at any time. Tenant approaches, during the pandemic, and this is probably more prone to renegotiation, but we talked about rent forgiveness, rent deferral, month-per-month extensions, blend and extend, early full extension. So these are all just compromise positions that landlords and tenants can take, based on leverage, who the landlord is, who the tenant is, what the market's like, what's the timing, and I'll talk about those preliminary considerations on one of the next slides. But these were all strategies that were employed during the start of the pandemic, and which could be useful going forward. It's a compromise. It gives the tenant some relief, and it also gives the landlord some recapture of any income that they might be losing from any rent abatement. Another item was the security deposit burn down, where the landlord might apply some of the security deposit to any of the rent owned, and then the tenant would replace the deposit. So, these are all just mechanisms to make sure the parties can, continue to operate. Landlords as landlords, and tenants operate in their business. And here it's all about flexibility and creativity. If the landlord and tenant are both good actors, there should be some way to meet in the middle on how to allow the tenant to stay in the space and thrive going forward. So I talked a little bit about the preliminary considerations, and I always talk about this at the outset of lease negotiation. And, you know, there's accounting issues for the landlord if they're a REIT. There's refurbishments, there's right sizing. You know, during COVID, we talked about, you know, what's the right size? You know, how can we convert an existing premises into what's appropriate and optimum for the tenant? Like I said, work from home policies. We don't know if all of our employees are going to be coming back to work. We don't know if we need more square footage to expand and social distance with our employees, or if we need less square footage because not as many people are coming back. So, you know, right sizing is a discussion that can be had between landlords and tenants as well. The main preliminary consideration here, though, is leverage. And it'll come into play when I talk a little bit more about force majeure, compromise positions or remedies. But, you know, who is the tenant? You know, who is the landlord? What's the market? If it's a renegotiation, what's the underlying lease language say? And again, if there's a lender. So having that third party consideration always, you know, can protract the negotiations. So, you know, if the tenant is a Fortune 50 or 100 company, they're going to have a lot more leverage than maybe a sole, you know, a mom and pop business or a sole practitioner. And obviously, if the landlord is an institutional landlord rather than maybe just a family-owned real estate business, they're going to have a little bit more leverage. So, you know, whenever you get into a negotiation of a new lease or renegotiation of an existing lease, it's always good to kind of take a step back and see where the leverage is. And, you know, if you go into a negotiation with that mindset, it makes it a little bit more amicable than adversarial. So some of the landlord asks and tenant guidance that we had during the pandemic and what might, you know, still be seen after we officially come out of the pandemic is, you know, financial and other information, especially if a tenant is unable to pay rent. You know, going forward, you know, the landlord is going to need to see the financial information, you know, showing that fact that you cannot pay. Because, you know, down here at the bottom, you do not want to ask for help if it's not actually needed. I'm not a litigator. I don't pretend to play one on TV, but I know that that's going to be a case or multiple cases that is litigated, right? Tenants coming to the landlord asking for help, you know, if truly they did not need it and their business was thriving, you know, during the pandemic. Another item is confirmation from tenants insurer. I'm not sure, you know, if you've talked to your risk management teams during COVID, I'm sure you all have, but business interruption insurance, a lot of tenants have it. What does it cover? So, you know, make sure you speak with your risk management teams regarding business interruption insurance. And then obviously we don't want to withhold rent. Certainly there could be some instances where withholding rent might be permitted under the lease, but in most instances it's not. You know, if a landlord's in a major default, you know, the tenant can always come back around and get that rent via damages, but it's not good to withhold rent up front. And, you know, most, if not all, force majeure clauses do not excuse the non-payment of rent or any monetary obligations for that matter. So with that being said, and kind of tying this all together, thinking about back to our preliminary considerations and leverage, you know, what we're seeing in lease negotiations for force majeure provisions, you know, there's still no excuse for non-payment of rent. That's just a flat out no, and I think most, if not all, tenants agree with that. But however, there is some compromise language that is creeping its way into some force majeure provisions based on the leverage. Like I said, if a tenant has a great deal of leverage, maybe they can get some expansion on what's included in a force majeure provision. So the most common one we're seeing is pandemic and epidemics defined in the force majeure clause itself. You know, I think there's going to be a lot of litigation surrounding, you know, acts of God. You know, what does that language mean? Does COVID-19 come under that general umbrella? it'd be a lot easier if a judge was reading a lease, in 5 years, God forbid something like this happens again, and she sees some language about, more of a specific language about pandemics and epidemics defined. So we talk about, expanding the force majeure provision to include that. And, we touch on, if there's any, novel infectious diseases such as COVID-19. We talk about shelter in place orders, stay at home orders. The premises has to close for business due to government intervention. So it adds a little bit more clarity on what might constitute a force majeure event. Again, still no excuse for non-payment of rent. In all leases I've seen, even if it's a highly tenant leverage deal, any event of force majeure is not going to excuse the non-payment of rent. And then the last thing I'll touch on is just some remedies that we've seen from a high level for tenants that have a lot of leverage regarding force majeure, and especially as it applies to pandemic and epidemic regulations. If you define that in your lease, and let's say pre-rent commencement date, let's say you're trying to build out your space, and Megan will touch on tenant improvements here in a minute, but let's say the build out period is delayed due to the pandemic or epidemic regulations. City permits shut down, city government offices shut down, the construction industry shuts down, you can't build out your space. There might be some wiggle room there where the parties select an outside date, right? So if it's shut down for a year and you cannot build your space, but the lease is signed, you might have an option for either party to terminate the lease. The writing might be on the wall at that point, and obviously the outside date is subject to negotiation, but that might be a pre-rent commencement date remedy that's agreed upon. Post rent commencement date, while we don't want to excuse the non-payment of rent, perhaps there could be some abatement that is negotiated, but there's going to be an outside date on that abatement. For example, you could have if the tenant's unable to operate at your premises and you actually close, and maybe these pandemic and epidemic regulations are not specifically, they're not specific to tenant, they're more broad, they apply to all tenants. Then tenant may have, some abatement there. And then maybe after that 4 months, if you get an initial 4 months, there might be an extra 4 months of a deferral period, which rent is then amortized on for the length of the term. That way, you're still giving the tenant some relief, but the landlord knows what its exposure is, knows what its risk is, and still can recoup that deferred rent throughout the lease at an amortized in an amortized fashion at an interest rate that's negotiated. So, and typically there's an outside date on that deferred rent. The abatement period and the deferred rent, could be a year. After that, it's done, right? I think tenant gets the remedy that they were seeking, and the landlord, can move on and lease the space to the tenant and receive the rent that it bargained for under the lease. So with that being said, are there any questions right now before we turn it over to Megan? We can do questions at the end, but if anyone had any kind of burning questions now. Okay, Megan, I'll turn it over to you. She's going to touch on some tenant improvement and challenges in the pandemic and coming out.
Thank you, Seth. So yes, as I mentioned, my name is Megan Thiels. I'm a third-year real estate associate at Allen Matkins. Prior to going to law school, I was actually a project manager at a construction consulting firm in Los Angeles, and I primarily did high-end residential builds. So I was on the residential side. I came over to Allen Matkins, started doing more of the commercial work. So I've been on both sides of actually being in the field, doing the construction type of work and doing the contracting side, both from a landlord's perspective, doing build outs and leases, and a tenant side, doing their own build outs and leases, as well as negotiating as a landowner against the general contractor. So I always love to talk about work letters and tenant improvements because I believe that it's something that's very near and dear to the hearts of both landlords and tenants. You know, what's the space going to look like? What improvements are going to be installed? And most of all, who's paying for it? And so the topics I'd like to touch on today are delays in construction, material unavailability, contracts with the general contractor, as well as trends in tenant improvements that we're currently seeing. Next slide, please. So of course, COVID, as we've already talked about, it's very recent in our memories. We're still dealing with a lot of these regulations, but especially at the beginning of the pandemic, everything came to a shutdown. Everything stopped, including construction. You know, there were these mandates that you couldn't do anything unless it was an essential service. And for a while, no one really knew if construction was an essential service or not. And because of this, nobody could get their build outs done. All of the construction schedules were delayed. There were these government mandates limiting capacity, placing curfews on people when people could leave their houses, these social distancing restrictions, and the requirement for masks and other PPE that were actually unavailable for a lot of people or cost prohibitive. And so all those things really delayed construction. On top of that, there were outbreaks, people were getting sick, people were dying, people still are dying. And if you were sick, you had to quarantine. And there was this mandatory paid sick time. And so this all together kind of created the perfect storm of nobody being able to get their tenant improvements done, even if it was a landlord that was responsible or a tenant. On top of that, because nobody could get their initial builds done, the contractors couldn't move on to their next projects. They couldn't get labor. And so it just kept extending these deadlines. And even though the construction schedules couldn't be completed on time, the leases may actually have rent commencement dates that were hard dates where people had to start paying rent. And that kind of feeds back into this force majeure argument that a lot of tenants had to employ, as Seth discussed. So these delays, of course, you know, it affects the construction schedule, it affects the lease commencement date, and it can also affect the rent commencement date. On top of that, there was material unavailability. So for instance, at the beginning of all this, you go to the grocery store, there was no toilet paper anywhere, right? So you go in and you realize production shut down and transportation, they're having issues getting people the things that they need on time. And that wasn't just for household toiletries. That also happened for things like lumber, steel, other materials that you need to construct. And because of that, the prices went way up and it just wasn't available. And so if you had construction drawings that specified specific things, like, you know, you need this specific type of granite, but they couldn't get that kind of granite, then either you had to come up and decide if you were going to substitute the material, or if you had to comply with what was in the construction drawings and just wait or pay a huge percentage increase in order to get it done. And in some leases, depending on how it was drafted, a tenant could be held responsible for these delays. So for instance, like I mentioned, if the lease has a hard commencement date, let's say May 1st, 2020, whether or not their build out is done, then per the terms of the lease, that lease commenced. Whether or not they could get in, whether or not they could finish their build out, they would still have to pay rent. And some work letters even provide that the tenant is responsible for a delay if material is unavailable and the tenant does not approve reasonable substitute materials. And in the work letters, they may not clearly define what a substitute material could be. You know, it may be that it actually has to be that specific thing or it has to be building standard, but these were all things that were very vague, and it caused a lot of confusion for a lot of people as to how they were going to get their build outs done, and it further delayed the process. And because of all of these delays, this also caused increased costs. And then there was the question of who bears the burden. You know, if it's a tenant build with a tenant improvement allowance not to exceed X amount, then anything over that tenant improvement allowance generally falls on the tenant. If it's a turnkey build out, where the landlord is agreeing to build everything to the construction drawings, then that generally falls on the landlord. And because of these issues, we have seen that there is a lot more emphasis in negotiating certain provisions of the lease now, as opposed to pre-COVID, because we've seen these issues arise time and time again. And some of the things that we now see as highly negotiated are the lease commencement date, where the landlord will often very hard, push for a firm date. Landlord needs to know when this is going to start. They might have lender requirements, they have certain obligations they have to meet, but also, of course, tenants may want a more flexible commencement date and may want to have their commencement date extended on a day-for-day basis for force majeure, where the force majeure provision may include delays because of COVID-19. We've also been seeing that in work letters and leases generally, that the lease is actually expressly stating whether or not COVID impacts extend certain schedules and certain dates. So that's something that gives a lot more certainty to the parties and takes away a lot of ambiguity. I've also been seeing a lot of provisions that expressly explain what happens for substitute materials, whether there's a certain time frame that the tenant or the landlord has to approve the substitution of certain materials, and what the standard is, whether it is reasonable discretion, sole discretion, things of that nature. Additionally, there's been quite a bit of negotiation expressly setting forth who pays what costs and when. So that takes away a lot of ambiguity. Of course, as Seth mentioned, how you negotiate the lease often depends on what kind of leverage the tenant may have. And so tenant may not have a ton of leverage in the lease, but there are certain ways to hedge against unanticipated costs and delays in the construction contract with the general contractor if the tenant is the one responsible for the build. Next slide, please. So for contracts with general contractors, you of course get to negotiate that, right? Like if you are a tenant that is responsible for building out the premises, then pursuant to the work letter, the tenant will likely be the one who hires the general contractor. The tenant will be the one who holds the contract. And so the tenant gets to have the opportunity to negotiate that contract with the general contractor. And via those negotiations, the tenant can align the delay concepts that are in the work letter with the delay concepts that are in the contract with the general contractor. So let's say the work letter says, you only get X, Y, and Z for delays in the construction schedule, and only X, Y, and Z are going to extend your lease commencement date or your rent commencement date. Well, then in the contract with the general contractor, you can also try to say that they are limited to those specific categories of delay for them to actually push out their construction schedule. Of course, not all general contractors are going to agree with that arrangement. They may have their own specific language that they want to use. And in those cases, you can use liquidated damages as a way to try to hedge against schedule extensions. And I'll talk about liquidated damages in just a second. The other way that tenants may want to try to hedge against unanticipated costs is by locking in prices for material and labors in the construction contract itself. So primarily, there are two types of construction contracts that will lock in prices. These are lump sum construction contracts and guaranteed maximum price contracts. And in these contracts, at least for the lump sum, generally the contractor says, okay, tenant, I will build out your space for $100,000. And now whether or not it actually costs the contractor $50,000 or $150,000 to build out the space, tenant only pays that $100,000 amount. So that's one way to hedge against the price of materials and labor going up. Then as far as liquidated damages go, this is actually something that will allow the tenant to hedge against both unanticipated costs and schedule delays. So liquidated damages are usually an amount of money that is specified in the contract as an amount that contractor will pay to the landlord or the tenant, whoever holds the construction contract, on a day-for-day basis for each day that contractor is late in hitting a particular milestone or substantially completing the job. The amount of the liquidated damages have to represent a reasonable estimate of the actual damages that a breach would cause. So for instance, if the tenant holds the contract and the tenant wants to put in a liquidated damages amount, then they could say that, okay, contractor, if you are not done with the project by June 1st, 2020, then I need to have $3,000 for every day that you are late. And these $3,000 represent the per diem amount that I would be paying in rent, that I'm obligated to pay, my operating expenses, things of that nature. And then, so this incentivizes the contractor to not only meet the schedule, but it also gives the tenant the knowledge that if the contractor is late, then tenant's going to get a certain amount of money on a day-for-day basis to cover the cost that that breach caused. Next slide, please. So when we're working on leases, we get to see a lot of very interesting space plans, right? There's some very cool build outs. And so over the course, like pre-COVID and now, there's been a few differences that I've seen. So for office leases, there have been a lot less open concept plans. So previously in big tech, there's been a lot of collaborative spaces, a lot of cubicles near each other for people to kind of collaborate and get to know each other, work together. And I've been seeing, at least in my practice, there's been a lot more individual offices, a lot more areas for social distancing. Next slide, please. With respect to retail and restaurants, there's been an even bigger shift. Pre-COVID, I recall that there was a big push to make things more about an experience, getting people to come in and stay, get to know each other and the people that are working in the retail area and get them to spend more money. But now there's been a lot smaller inventory and a much larger online presence. And there's also been a lot more pickup windows and designated areas for customers to come and pick up orders and then leave immediately. So it's much less about having an experience. With respect to restaurants, of course, there's been a huge emphasis on outdoor dining, which I've heard is here to stay. And I'm actually very excited about this, especially for Southern California. There's also been a much smaller emphasis on dining rooms, especially for fast food. And the most interesting thing I've seen lately was actually announced this month. So Taco Bell has announced this concept called their Defy restaurant. And this restaurant concept actually does not have any dining room whatsoever. It's 4 drive-through lanes, 3 of which are for either mobile orders or delivery drivers, such as DoorDash, Grubhub, Uber Eats. And then there's only 1 lane that is for people who actually want to go up and order there. And so the concept is the customer pulls up with their phone, has a QR code that is scanned, and their food is beamed down to them. You literally never have to speak to anyone that works at Taco Bell, and the restaurant is above these drive-through lanes. So it's just a very different feel to the pre-COVID life of having an experience, getting to know people. It's very much, give me my food, I'm gonna go. So that's just a very interesting shift that we have seen. But anyway, that's my spiel on tenant improvements and construction contracts. If there's no specific questions now, I'll hand it over to Mike.
Thanks, Megan. Looks like maybe people are reserving questions at the end. That's fine. As I mentioned earlier, my name is Mike Holmes. I am a real estate partner at Allen Matkins. I'm also a recovering litigator. So I was a litigation partner with the firm a few years ago, and it's hard to shed that prior condition. So I view all of my deals through the lens of how things can go terribly wrong. And that's probably a good way to look at things. Occasionally can also be a curse, but I tend to do that to be sure, because all of us here, our goal is to keep everybody out of the courts. So the hope is that we keep our deals clear and unambiguous and everyone stays out of court. Anyway, I've been doing this for a while, and when I first started, the ADA was booming, and everyone was being sued, and it didn't really slow down until COVID hit, and we saw a lot of slowdown for obvious reasons. Nobody was open, and nobody could go to a retail shop and or a restaurant, including folks who are disabled. And so we saw a bit of a slowdown in that litigation, although it didn't completely stop. There was a trickle still, but we did see a slowdown. Now that things are opening up again, we're starting to see more and more of these lawsuits. And so I want to talk about an ADA disclosure statute that is in all the leases you've probably seen over the last couple of years here, but I kind of want to drill down on it. But before we do that, the other trend that we're seeing a lot of are animals, service animals and otherwise, that are being brought to retail centers, office buildings, other public accommodations. And I think we're seeing this because, number one, more disabled folks are in the workforce. Number two, I think a lot of people, this has been a stressful time for a lot of people, and a lot of people need the comfort of an emotional support animal, if not a service animal. And number three, I think possibly people working remotely from home have realized that maybe they need their animals or have relied on them more than they thought, and maybe vice versa. So we are seeing a lot more of these issues pop up. So I kind of want to walk through some of it because we're getting a lot of calls from landlords and tenants alike about what their rights are when an employee, especially one that works maybe at a retail center or an office building, wants to bring their animal in, and there's some, we'll get into this, but there's some tension perhaps not only with their employer but also with the landlord. So let's just start off by talking about service animals. They are animals that are individually trained to work or perform tasks for a person with a disability. Importantly, a service animal must be trained to take a specific action when needed to assist a person with a disability. The common examples are dogs who guide the blind or alert people who are deaf. But other examples might include a person with diabetes who has a dog that is trained to alert her when her blood sugar reaches high or low levels. Or a person with depression, they might have a dog that's trained to remind them of their medication. So there are different tasks that these animals are trained to do and to help the disabled. But the task, whatever it is, must be performed it must be directly related to the person's disability. Service animals are working animals, they're not pets. And so we'll talk about that distinction in a minute between a service animal and an emotional support animal, for example. But one big distinction that you got to keep in mind and makes it a little easier to identify is that service animals are almost exclusively dogs. Any breed of dog can be a service animal, but not your pet rat or your weasel. They can't be. There are some times, some circumstances when a miniature horse can be a service animal, and it's the only animal besides a dog that can be a service animal. But it's only when they can be reasonably accommodated with a particular facility. And some of those factors include, not to put a visual in your head, but when a miniature horse is housebroken, that's one of the factors. Whether it's under the owner's control, whether the facility can accommodate the size and weight of a miniature horse. They're usually 24 to 34 inches tall, and they weigh between 70 and 100 pounds. So they're not small animals, and the facility has to be able to accommodate them. And another factor is whether the miniature horse's presence will compromise legitimate safety requirements within the facility. So just to touch on that a bit, so it's on your radar that miniature horses at times can be service animals, but for the most part, we're looking exclusively at dogs. They're not required, service animals, dogs are not required to wear a vest or to have an ID tag or a specific harness or anything like that. So it can be difficult to know whether the dog is actually a service animal or not. It's something that the owner doesn't have to prove. They don't need any documentation showing that the dog was certified or professionally trained or licensed, because the ADA doesn't require certification or professional training or licenses. People with disabilities have the right to train their dogs themselves, and they don't need to have a license or certify them. So it makes it tough to really know whether a dog is a service animal. And to add to that difficulty, unfortunately, landlords and employers and others are very limited in the inquiry that they can make as to the dog. If it's not obvious whether the dog is a service animal, the landlord or the employer can only ask two questions, and only these two questions. Specifically, is the dog a service animal required because of a disability? Yes or no? And number two, what work or task has the dog been trained to perform? The landlord or the employer is not allowed to ask them to demonstrate the task that the dog can perform, or to inquire about the nature of the person's disability, or, as I said earlier, require any sort of documentation. They just can ask those two questions. So how do you know if there really is a need for the service animal, if that's a real need? In a nutshell, you just have to take the owner's word for it. They answer those two questions, and if they answer them in the affirmative, and they tell you what the task is that the dog has been trained to perform, and that's a task that falls within some of the examples I mentioned earlier, then you're pretty much going to have to rely on that unless there's evidence to the contrary. So let's talk a little bit about, real quickly, the distinction between service animals and emotional support animals, because that might help with this, with kind of ferreting out this distinction as well, and the definition of service animals. So as I mentioned earlier, a service animal is trained to perform a specific task that's directly related to the disability. An emotional support animal, on the other hand, does not perform any task related to the person's disability, but rather provides comfort simply by being present with the person. They are providing comfort, but it's just their presence that's doing that. The landlord's obligation in California for office buildings, retail centers, restaurants, that sort of thing, public accommodations of any type, they are required to allow service animals to enter their centers and their buildings, but they're not required to allow emotional support animals. There's a different standard for employers and other folks like airlines and residential housing who have different standards that can allow emotional support animals. But those standards don't apply to landlords of commercial public accommodations. So you probably can tell there's going to be a tension here, and there's a tension between the tenant employer, who may happen to be doing business in a public accommodation like a retail center or an office building, and the landlord of that retail center or the office building. And I've had this come up recently with all the new, with everybody coming back to work and bringing their animals, emotional support animals as well as service animals. And there is a real tension here between what the employer wants to do or is allowed to do and what the landlord is obligated to do. And the rules for the landlord and the rules for the tenant employer are different. So the question is, can the employee bring his or her emotional support animal to the workplace? And there's no statutes, case law, or online resources that address the issue directly. But I've discussed it with federal and state agencies, and the unwritten bottom line is that regardless of the obligation of an employer that the employer may have to its employees, the landlord is not required to allow a non-service animal into its office building or its retail center. So as a result, the employer would not be able to allow the employee to bring the animal into the workplace if the landlord doesn't allow it. But because of that, the employer can claim an undue hardship because it's unable to allow the emotional support animal in the workplace, provided that the employer provides the employee with an accommodation, if one exists. So, for example, although the emotional support animal may not be allowed in the workplace because the landlord doesn't allow it, they may be able to accommodate the employee and allow them to work remotely from home. Or they might transfer the employee to another office that does allow emotional support animals. Or they might allow the employee to bring another item to the workplace that would provide the emotional support required by the employee. Those are all accommodations that an employer might be able to make to an employee, given that they can't allow an emotional support animal into the workplace. Now, just to emphasize again, if the animal is a service animal, then the landlord's going to have to allow that animal to come into the workplace. We're only talking here when the animal is an emotional support animal, and the landlord therefore is not obligated to allow the animal in, and the employer therefore cannot allow the animal in as well. So anyway, any questions on that really quick overview of service animals and emotional support animals before we move on to discussing an ADA disclosure statute? Happy to answer any questions before we move on. Okay. So again, I know we don't have a lot of time here, so quickly on the Civil Code section 1938, which is a disclosure statute that was enacted a few years ago. It actually went into effect back in 2017. So you may have already been seeing these disclosures in your leases for quite some time now. But I wanted to walk through some of the particulars and some of the unresolved issues with respect to the statute. So disclosures, these disclosures under section 1938 are made in the lease documents. Unlike other accessibility statutes, section 1938 requires the disclosures to be made in the lease rather than requiring barriers to be removed at a retail center, for example, or other actions. These are just disclosures that are being made. And because they're being made in the lease, it's really just being made to the parties of the lease, the landlord and the tenant. So it's unclear where this is all going to go. We haven't seen a lot of litigation on these disclosures yet. With how litigious ADA has been over the last several years. I mean, we're talking tens of thousands of lawsuits in California alone, usually to extort settlements ranging from $1,000 to $100,000. It's unclear how much litigation, if any, will be generated by this disclosure statute. Again, we haven't seen much at this point. There's some differences, right? I mean, one I mentioned earlier, this is between owners and tenants, landlords and tenants. They're the parties to the lease instead of the disabled public being involved. And in addition to that, tenants might want out of their leases rather than wanting to extort a monetary settlement. So there's some differences that may have an effect on whether and what type of litigation we see. The statute applies to public accommodations. Again, those are commercial areas open to the public, such as retail, restaurants, my law office. These are all public accommodations. So it's going to apply to those. And it applies to inspections that are prepared by a certified access specialist, a CASP. There's different types of CASP reports that are prepared, and sometimes those differences are meaningful under some of the accessibility statutes. But for this disclosure statute under section 1938, there's no difference. It applies to all CASP reports. So in some ways that makes it easier. You just know it's going to apply if you've got a report. So let's move to the next slide and discuss some of the sections in particular and how we interpret some of the language, and not all of it's very clear. Surprise, surprise. I mean, it's unfortunately the way California statutory law is at times. But subsection A of section 1938 says that a commercial property owner or lessor shall state on every lease form or rental agreement whether or not the subject premises have undergone an inspection by a CASP. So the usual disclosure here is that the premises have not undergone an inspection. A lot of our clients have not had that done, and so that's usually the disclosure. But if the landlord has had an inspection, then obviously you need to disclose the opposite, that there has been an inspection. But I want to touch on a couple of the ambiguities in here. The statute does not address amendments. It just says every lease form or rental agreement. But I believe that the best practice is to make the disclosure in the next lease amendment and after any material modification of the space. In both of those instances, I believe it's the best practice and prudent to do that, even though the statute doesn't give you a lot of guidance. The statute also mentions the premises, but it doesn't say anything about the building or the center. So because of that, all that needs to be disclosed is an inspection of the premises. You don't need to talk about an inspection that was done in somebody else's premises or something that was done in the common areas. But as a side note, practically speaking, CASPs will need to inspect the path of travel through the common areas as part of his or her CASP report on the premises. So even though it doesn't talk about common areas, those are areas that a CASP is going to inspect as part of the report. It also talks about an inspection by a CASP, not a city inspection. And just want to emphasize here that a CASP inspection is not the same as a city inspection. City inspectors don't know the law, they're not held accountable, and their inspection simply doesn't qualify as a CASP inspection. I can't tell you how much new construction that I've seen that does not comply with the ADA. And you know, my clients are just beside themselves. Like, we've had this inspected by an inspector. What do you mean it doesn't comply with law? It's just very frustrating. So next subsection real quick, subsection B reads that if the subject premises have undergone inspection by a CASP and there's been no alterations, the commercial property owner shall provide a copy of the report prepared by the CASP. So interesting, first just note that the disclosure is not a disclosure in the lease here. The disclosure is actually the document, the report. That's what needs to be disclosed if it exists. If you don't deal with this disclosure statute regularly, you may want to make a note in your lease form that the report, if it exists, needs to be provided. You'll note that this subsection is conditioned on no alterations that have impacted the premises compliance. And if there has been some modifications, then I think the statute presumes that the CASP report may be outdated or not useful. And therefore, we'll see in subsection C, we'll get to in a minute, that's where that would fall. But I think that's why you have this condition on the alterations. And in another important, it's not quoted here, but the statute also makes it clear in this subsection that the owner can require the agreement, can require the tenant to agree separately that the CASP report remain confidential. So even though you provide a copy of the report, you can, the landlord can require, or the parties can agree that the report will remain confidential. And that's usually to the benefit of both parties. The last thing you need is an outside third party to be suing both the landlord and the tenant, and because of some sort of report that was leaked. Okay, next we'll talk about subsection C, which reads, the prospective tenant shall have the opportunity to review any CASP report prior to the execution of the lease. So here you'll note there is no condition on alterations like we saw in the prior subsection. It's any CASP report. And this particular subsection goes on to say that if the report is not provided to the prospective lessee at least 48 hours prior to the execution of the lease, the prospective tenant or lessee shall have the right to rescind the lease based on the information contained in the report. And they have that right to rescind for up to 72 hours after the execution of the agreement. So this is critically important. If this report exists, it does need to be turned over if you're a landlord. And as a tenant, you want it to be turned over. Otherwise, there is this risk of rescinding the lease, which normally neither party wants, but it's possible that it could happen. So this is, again, not in the lease form. The disclosure is the report. And I just got a question that popped up from somebody. This does apply to subleases, and a lot of times you'll see a reference to the lease in the sublease, and kind of piggybacking on the language of the lease, because a lot of times the sub landlord doesn't have access to that information on what's been inspected or what hasn't been inspected. So they'll often be there'll be the disclosure, but there'll also be a reference back to the master lease. Thanks for that question. So as I was saying, this is not in the lease form. The disclosure is the report itself. So again, if you don't deal with the statute regularly, you may want to make a note in your form that if it exists, it needs to be produced 48 hours prior to the execution of the lease. It also, this provision also states that making any repairs or modifications necessary to correct violations that are noted in the CAS report is presumed to be the responsibility of the commercial property owner, unless the parties agree otherwise. So that is the presumption. It is often part of the negotiation with the parties, so that it can change or be modified, but the statute presumes that that's the case. All right, and I know we're running out of time here, so real quickly, the last couple subsections here. Subsection D states that if the CAS report states that the subject premises meets applicable standards, which is the language that CASPs use when there's no barriers, then the landlord or the owner must provide a copy of the current disability access inspection certificate and any inspection report within 7 days after the execution of the lease. Again, the disclosure is providing a copy of the documents that are referenced here. And the owner has a little more time to produce a report, presumably because everything at the premises is compliant. And then the last subsection real quick is subsection E, if the premises have not been issued a disability access inspection certificate, which is the vast majority that I deal with, the property owner must state the following. I'm not going to read it, but there is a provision here, block quote from the statute, and this quote, this disclosure should be quoted verbatim in the lease. Now, if you read, you can read through it yourself here, but you'll note that per the language in this disclosure, the parties can make express pre-inspection agreements in the lease to decide how things would be handled in the future. Sorry, that was a very quick rundown. I know we didn't have a lot of time, but happy to answer any questions, as I know Seth and Megan are as well, if anyone has them.
It looks like you have one question in the chat, if you can see it.
Let me check real quick here. Yeah, I addressed. I addressed the one about the subleases, and I see there's another TV show about miniature horse service animals. Yes, I think all of this is getting more play now as we're seeing more and more people come to work with their service animals and with their pets. So,
Mike, I have a quick question, if you don't mind.
Sure.
You mentioned that even lease amendments, and so we do a lot of short-term leases for like biotech space, and so we have leases that were executed prior to 2017. Is it a best practice then for renewals or extensions to include like that CASP language in those subsequent revisions or amendments rather?
Absolutely,
Okay.
and especially when if you've got a if the amendment is for an expanded space, definitely want to have it in there. But yeah, any amendments at all, any renewals, I think best practice would be to put it in there.
Okay, thank you.
Sure.
All right, well, here on the screen are our contact information in the event that you have any questions that pop up later. Feel free to call or email us at any time. Happy to chat offline about any questions you may have about the material.
Wonderful. Thank you.
Thanks. It's a pleasure.
Thank you all.